And you are good to go.
Terrific. So, good afternoon. My name is Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. I'd like to thank the Better Business Bureau for inviting us back today to talk about the Connecticut Paid Leave Program. Before I jump into the slideshow, I just want to give the Better Business Bureau, our hosts here, an opportunity if there's anything you want to say before I jump in.
Sure. Hi. Yeah. Thank you, Erin, for talking to us again today. Welcome to our accredited businesses too, who are joining. Today, we are talking about private plans. So if you are a business owner who currently has a paid family leave plan and you want to keep it, Erin's going to be talking about what you have to do in order to keep that plan or opt out of the state's plan. And then any other questions as far as possibly creating your own plan as well. If you don't have one and you kind of want something else custom to your employees that approves through the Connecticut Paid Leave program. So thank you again, Erin. We look forward to all the great tips and info that you're about to give us. So thank you.
Great, thank you so much. Just a couple of housekeeping tips. I'd like to welcome our CEO, Andrea Barton-Reeves, as well as our extraordinary assistant, Amber Forrest, who'll be helping manage today. If you have questions during the course of the presentation, please put them in the Q&A, and that will enable us to keep track of them and make sure that we're responding to them. As I go through the slide deck, you can feel free to add your questions, and Andrea and Amber may be able to respond to them right away, or we'll save them to the end. The slides will only take about half of the time, so we have plenty of time toward the end. I also want to point out that we are recording so that this will be available to you to share later on. We'll share it with the Business Bureau as well as the slide deck. So it will all be available to you to review at a later date as well. So I'm going to go ahead and share my screen so I can get to the slide deck.
You are good, Erin.
Okay, thank you, Amber. So as Luke said, we're going to focus today on the private plan aspects of the Connecticut Paid Leave Program. But first, let me just tell you a little bit about myself. As I mentioned, I'm the General Counsel for the Paid Leave Authority. I joined the authority this past fall after working at the Department of Administrative Services for 14 years. Been an attorney for over 20 years, focusing on employment law issues, administrative law, and other related matters. But the FMLA has been an area of particular focus for me through my career. The Connecticut Paid Leave Authority is a quasi-public agency. We were created by Public Act 19-25 with the mandate to help address the need to provide financial relief to families who are experiencing situations where they can't work because of their own serious health condition or serious health condition of a loved one. So they can't work, but they are experiencing the financial distress of not having any income coming in. And so that's the gap that we fill. We provide employees with a pathway to access paid family and medical leave benefits. And we also help empower employers, administrators, healthcare providers, really everyone involved in the FMLA process by giving them the tools they need to understand their roles and providing support. The Connecticut Paid Leave Authority is responsible for engaging in outreach and engagement, which is why we love our partnership with the Better Business Bureau and really appreciate this opportunity to speak with you. We also develop the policies and procedures needed to run the program. This is a brand new program, so we're starting from scratch with our policies and procedures, and that's what we've been working on. We are also responsible for establishing the contribution rate and receiving the contributions. Hopefully you are all aware that the contribution rate is 0.5%, and those contributions were required by law to start being deducted as of January 1st of 2021. So if you are an employer, your responsibility is to take that deduction from your employee's wages. And then you will remit those contributions to the authority at the end of the quarter. It is an entirely employee-funded program, but the employer is responsible for handling the payroll pieces of it. We also have the responsibility of approving and auditing private plans, so we'll focus on that today. But I want to point out that claims for paid leave benefits will begin in January of 2022. So just a few key dates to keep in mind. We have our Connecticut paid leave website, ctpaidleave.org, has been in operation since September. And in November, we started the employer registration. So if you are not already registered, please go to ctpaidleave.org and register your business. You need to be registered in order to make the contributions or to file for the private plan in lieu of the contributions. As I mentioned, on January 1st was the beginning for the contributions to be deducted from employee wages. Starting earlier, or actually at the end of last month, we opened the functionality for employers to submit applications to offer private plans. And so any employer that wants to have a private plan in lieu of participating in the public plan option needs to get their applications in by the end of March in order to be forgiven for the making contributions for Q1 of 2021. Those quarterly contributions are due at the end of every quarter, but we are trying to work in the same cadence as Department of Labor for payroll and unemployment and Department of Revenue Services for payroll taxes. And so we also give a 30-day grace period. So even though technically the due date is the end of the quarter, you have until the end of the month following to get your payments in. Starting in December of 2021, we will start receiving applications for benefits, and those benefits can start being paid in January of 2022. Okay, so what is this Connecticut paid leave program? So under the Connecticut paid leave law, all employees working in Connecticut for a covered employer are required to contribute 0.5% of their wages to the Connecticut Paid Leave Trust. So that trust is what funds the benefits. The only exception is if an employer receives permission from the authority to offer their employees a private plan instead. If the employee works for an employer in Connecticut and has earned at least $2,325 in their highest earning quarter, when we look at the first four of the most recent 5 quarters, and they have a qualifying reason, they can receive benefits from the Connecticut Paid Leave Trust. If the employee works for an employer with an approved private plan, that employee will go to their employer for income replacement benefits instead of coming to the Connecticut Paid Leave Trust. So I did mention covered employers, and there are a few employers who are not part of the program. So let's just talk about them first, because if you are not part of the program as a covered employer, you do not have to file for a private plan, you do not have to register. But just to be upfront about it, the list of who is covered is incredibly broad, and the list of who is not covered is actually relatively small. Who is covered? Well, any employer who has 1 or more people working in Connecticut. So that includes nonprofit organizations, that includes private sector employers with unionized workforces. It includes employers who are not subject to unemployment obligation. If you are an employer with 1 or more people working in Connecticut, you are covered, with the exceptions I'm going to talk about in 1 second. If you're a sole proprietor and you have employees, you are covered as far as your employees are concerned. And you, as the sole proprietor, have the option to join in as well. Similarly, if you're a self-employed individual, you are not required to participate, but you have the option to join. If you are that sole proprietor or self-employed individual who chooses to join, you do have to stay in the plan for 3 years. And you would make your contributions based on your self-employment income as opposed to your wages. So who's not covered? Well, the federal government. the state does not have the authority to impose our statutes on the federal government. So employees of the federal government are not part of the program. The state of Connecticut is sort of a hybrid. We are excluded except as to our covered public employees. Similarly, municipalities and local or regional boards of education are excluded unless they have covered public employees. And then non-public elementary or secondary schools are also excluded, meaning if you are employed by a non-public elementary or secondary school, you do not make contributions and you cannot participate in the benefit program. All right, who are these covered public employees that I mentioned? Sorry, let me go back. Well, for the state of Connecticut, any non-unionized employee is covered. So managers, appointed officials, elected officials, we all participate by contributing 0.5% and we can apply for benefits. Unionized state employees are excluded. So they would only participate if they collectively bargain for participation. With municipalities and local or regional boards of education, they are currently excluded, but if their unionized workforce collectively bargains for participation, then everybody who works for that town or that board of education, union or non-union, would be covered. Okay. For purposes of today, I think we're going to focus primarily on those who are covered, right? So these are the private sector employers who have one or more employee working in Connecticut. You have to participate, and your employees are entitled to receive paid leave benefits from one of two ways. One way is to make the contributions to the paid leave authority, and then they can apply to the authority for their benefits. The statute also allows for this private plan alternative. So Section 3149 of the Connecticut General Statutes permits employers to apply to use a private plan to meet their obligations. If you have an approved private plan, then the employer would administer the claims for benefits. The employer is entitled to withhold a portion of the employee's wages, but they are not required to do so. But if they have an approved plan, they do not have to remit the employee's contributions to the paid leave authority. If the employer chooses to withhold any portion of their employee's wages with a private plan, the only purpose can be to administer that private plan. They cannot use it for any other purpose. They cannot pool that money for any other benefits that they offer. And that withholding cannot exceed the contribution rate established by the Connecticut Paid Leave Authority. The private plan has to offer the same or better benefits as the Connecticut Paid Leave Program. It needs to cover all of the reasons that the Connecticut Paid Leave Covered Program, all of the reasons the Connecticut Paid Leave Program covers. So that includes your employee's own serious health conditions. It includes giving them time off to care for a family member with a serious health condition. It includes pregnancy, organ and bone marrow donors. It includes military family leave and family violence leave. Most short-term disability policies that you see in the market do not cover all of those reasons, and therefore simply having a short-term disability or a long-term disability policy will not be enough. In addition, it must offer the same income replacement and for the same amount of time. As I mentioned, it cannot cost the employees more than the public plan, and it must cover all of your employees. So if you are a multi-state or multinational, the plan only has to cover your employees working in Connecticut, but it has to cover everybody in Connecticut. You can't have a private plan for your executive officers, but then ask your manufacturing workforce to participate in the state program. Because the Connecticut Paid Leave Program is entirely employee funded, the legislature made a point of saying that it's the employees who have the ultimate say as to whether they want to participate in the paid leave program established by the authority or to participate in a private plan run by the employer. And therefore, they put in statute that there must be a vote of the employees, and a majority vote has to approve that private plan. So we have all of the details about what the private plan must include in our private plan policy and procedures document, which you can find on our website, This is a screenshot of if you go to the I want to apply for a private plan page on our website, you'll see the information on the right-hand side of your screen. You scroll all the way down, you can connect to the actual policy document itself. Just briefly, a private plan can consist of one of two options. One option would be an insurance policy that you purchase from an insurance provider. The insurance policy and the provider have to be approved by the Connecticut Insurance Department. Alternatively, you could offer a self-insured plan. If you choose to offer a self-insured plan, you have to support that with a surety bond that runs to the benefit of the authority. I think it's important to note here that the surety bond does not fund the benefits themselves. A self-insured plan or an employer with a self-insured plan has to have a way of funding those benefits and also has to have a surety bond so that the state and the employees are protected in the event that the employer can no longer offer that plan and the employees have to come to the authority. Right now, we have several employers or insurers who have approved plan documents, and this is a list of them. We are working with the insurance department, and they notify us anytime a new insurer has filed approved documents. So there are a number available. Just a note on the wording that you see. Right now, we're talking about declarations of insurance because we're in what we're calling the interim period. We've been working with the insurers for several months now, and they have advised us that they need more information to develop their final policies than we had available to them when they wanted to go to market in the fall. So we created what's called an interim period. Basically, insurers are able to sell and employers are able to apply using a declaration of insurance, which lists all of the statutory requirements. That declaration of insurance is essentially a binder. So an employer can work with the insurer to obtain a declaration of insurance, apply, and be excused from the contribution obligation. However, we are continuing to develop the information that insurers need relating to the claims administration and some of the terms of the policies. And insurers have committed that they will update their declarations with final policy documents within 60 days of when we publish this policy filing guidance notice. And so then everything will get supplemented at that point in time. To make things fair for employers who wish to have a self-insurance option, we've created a parallel declaration of self-insurance. And actually that declaration template can be found on that private plan policies and procedures document I showed you on the previous slide. So right now we're working to develop those policies and additional information that insurers want. We will publicly post that document for comments, and then our board of directors will vote on that final policy filing guidance notice. Once that happens, insurers will update their policy documents and employers will supplement their applications and sort of get the final policy document registered with us. Once we get through this process, we will no longer accept those declarations of insurance, those binder documents. Instead, any new plans would have to be filed using the final policies. Okay, so what is the application process right now? Well, it starts with registering as an employer. You just go to ctpaidleave.org, and it's a relatively simple process to register if you haven't done so already. There are videos and helpful guidelines about how to do it. It takes most employers about 10 minutes to do. As part of the registration process, we do ask for you to indicate if you're interested in applying for a private plan. This helps us tailor our communications to you to make sure that you are aware of the private plan requirements. Before you can actually apply for a private plan, you need to select a plan. You need to educate your employees and hold a vote. Once you've done all of that, you go back into your account, which you created when you registered. You click on your business name, and then you click on a tab for Apply for Private Plan. Again, that is a very short process. It takes most employers less than 10 minutes. The real work is what happens after you register and before you apply. As I mentioned, you have to figure out what kind of plan you want. So you either identify an insurer to work with based on the list of insurers who have approved declarations, or you develop a self-insured plan using that self-insurance declaration document we have as Exhibit A to our policy. You need to educate your employees about the plan you've chosen, and that includes providing them with what we call a plain language guide. The plain language guide is intended to help your employees understand what they're voting on. A template of that plain language guide is attached as Exhibit B to our private plan policy and procedure document on our website. So you have to give your employees the plain language guide and the plan documents. We want you to give them at least 2 weeks, and then you have to hold an anonymous vote. A majority of all of your employees working in Connecticut must vote in favor of the plan. If you have 100 employees and only 45 vote at all, then you don't have a majority. Even if all 45 say yes, you need to have a majority of the 100 employees to have it constitute a true majority. As I mentioned, if you have a self-insured plan, you also have to obtain a Shorty Bond that runs to the value of the authority, and it has to be equal to the estimated value of a year's worth of contributions. We do have a Shorty Bond form that will be shared with the Better Business Bureau, so if you're interested, you can obtain it from them. It's also being posted on our website. As I mentioned, the plain language guide is really intended to make sure your employees understand what they're voting for. We've outlined the information it needs to include, but it's also something that can be modified or expanded to enable you to explain to your employees what your private plan offers. The information has to be accurate, complete, and non-coercive. If you've decided, for example, that you're not going to charge your employees for the private plan, or you're going to charge less than 0.5%, that's information you want to include. You need to give it to your employees at least 2 weeks before the vote, and then you will also upload it with your application so that we can review it. Both the plain language guide and the declaration need to be given to your employees at least 2 weeks before the vote. You also need to tell your employees what the vote will consist of, how the vote will be handled. We ask that you use the same method of distribution that you would use for any other legally required workplace information. So however you're getting your employees the information they need about open enrollment or about required postings, use that so that everyone has the opportunity to understand and review it. If you have employees who are currently out on leave right now, you need to get the information to them. Similarly, if you have employees working remotely, you need to make sure they have access to this information. We want the vote to be anonymous because we want employees to be able to vote as they see fit and not worry that they're going to tick off their employer by the way they vote. And the results must be capable of independent after-the-fact verification. So getting everybody into a room and, putting their heads down on their desk and raising their hands is not an effective way of doing this. Secret ballots, if you are small enough and you have people in the office, that could work. What we're seeing is that a lot of people are using online voting apps or even SurveyMonkey or things like that, which are capable of anonymity. We want to make sure the question is very clear and consistent, so we've given you the language. Do you approve the company's private plan to provide benefits required by the Connecticut Paid Family and Medical Leave Insurance Act? Yes or no? The majority of the employees means at least 50% plus one of the total number of employees working in Connecticut said yes. There are some other requirements, including making sure that the documentation is accessible, that the method of voting is accessible, and that's all included on our private plan policies and procedures document. So when you apply, you're going to go in through your account, click on the tab for apply, and you'll upload your plan document and your plain language guide. If you are using a self-insured plan, you'll also upload your Shorty Bond. We're going to ask you to provide a little bit of information about the employee vote, the method you used, and how many employees you have, and how many voted yes and no and didn't vote. And you are required to attest that you complied with the voting procedures, as well as that you will comply with the private plan requirements. Please note that we do have the right to audit employers who have private plans, so we ask you to maintain all of the documentation associated with it. Just really briefly, we want to show you how simple the application process is. These are some screenshots. You're going to tell us if it's an insured plan or a self-insured plan. If it's an insured plan, you'll identify your carrier. With the declaration, you may not have a policy number, but you will have some basic information that you will provide to us. And you're going to upload the information, as I said, and then you're going to make sure that you check all the boxes to attest that you complied with the voting procedures, and that you'll give us the information about the vote itself. If a majority of your employees did not vote in favor of the plan, you won't be able to move forward. And then you're going to acknowledge that you understand your obligations to comply with the law and to provide the paid leave authority with the information we need. We have certain legislative reporting requirements, and so we'll be working with employers who offer private plans to ask them for information about the claims that they receive, and some demographic information. We also want to just point out that there are reasons that your plan approval could be withdrawn. So we just want to be very clear about all of that in the application process. We are accepting applications. We have as our service level agreement that we respond to all applications within 10 business days. In fact, we've been approving them much, much more quickly than that. Right now, we're saying that the applications must be approved no later than 30 calendar days before the end of the quarter in which they go into effect. So for that, it means that to be excused from the obligation to remit contributions in Q1 of 2021, your private plan must be approved no later than March 31st of 2021. If it's not approved by that date, you will be subject to making contributions to the paid leave authority. And those contributions will not be refunded if you end up applying for a paid leave private plan later in the year. As I mentioned, if you meet all the application requirements during the interim period, you will receive a provisional approval, which will be finalized once you submit the final plan documents. If you do not submit the final plan documents, or if there are any other reason you do not have a plan in effect in January of 2022, the employer is going to be subject to the requirement to pay all of the contributions owed, retroactive to January 1st, 2021. And if you haven't been collecting contributions from your employee throughout the year and holding them in reserve, then you as the employer will have to make up the difference out of your own funds. You cannot collect contributions retroactively from your employees. The plans will be approved for 3 years unless the employer changes its private plan. If you intend to change your private plan, you do have to go through the whole vote and application process. If you have a self-insured plan, we do need updated information to make sure that your Shorty Bond is accurate and up to date. So that's going to be requested on a yearly basis. We have several grounds for denial or revocation. For employers like you who are interested in actually learning about the private plan in advance, we're not worried about you guys, but we want to be clear that the private plan is a serious undertaking and obligation. And so it's important for everyone to know that we will audit these private plans. We will take complaints seriously. And if we determine that an employer has threatened or coerced the employees in connection with the private plan vote, or fails to pay benefits or pays benefits untimely or in a discriminatory fashion, we will withdraw the approval. We can also withdraw the approval if you fail to maintain the Shorty Bond for a self-insured plan. Obviously, misuse of the private plan funds is a huge problem and will certainly be grounds for denial or revocation, as well as most likely other legal problems. Failing to provide the information we require or providing false information to either the authority or the insurance department, or in any other way failing to comply with the Connecticut Paid Leave Act is grounds for denial or revocation. Again, the employer with a private plan is standing in the shoes of the Connecticut Paid Leave Authority, and like us, has to comply with the Connecticut Paid Leave Act. For those of you who have an insurer or a third-party administrator running your program, you need to be aware that if you direct your insurer or third-party administrator, or if they engage in that behavior, any of these behaviors, that would also be grounds for revocation or denial. We've got time today to do a lot of questions, but in case you think of more questions later, you can check out our website, ctpaidleave.org, and look at the frequently asked questions. We also have videos, including video on how to apply for the private plan. If you have additional questions, you can always reach us through our Contact Us portal on the website, and that is staffed by a team who will respond to your emails. If necessary, we can also schedule calls. All right, before we go to questions, I just want to leave you with this slide. This is probably the most important thing to know. Register. If you haven't registered yet, register now. It is the way to make sure that you can be very familiar with your obligations. It helps us know that you have these obligations. You won't be able to remit the contributions or apply for a private plan without registering. So do that. If you have a third-party payroll provider, you want to make sure that they are set up to process the wage withholdings and remit. Even if you're thinking about applying for a private plan, you really want to make sure that you've got your wage withholdings being processed right now so that you can be in the best possible position. Again, if your plan is denied, you're subject to those withholdings, and you want to make sure you're taking it in a timely fashion. Please educate your employees. Let them know what's going on. We have all sorts of information for you and for your employees on the website, including an employer toolkit, which includes posters, mailers, paycheck stuffers, anything you could think of to help your employees understand what you're doing. And then if you are offering a private plan, you can go to the website to get that private plan template so you can educate your employees about your proposed private plan. And check out our website regularly. We're updating it really every 2 weeks. We've got FAQs that we've been updating every 2 weeks. So check us out, make it a favorite, and see what we're doing. All right, I'm gonna stop sharing and go so that I can see what kinds of questions have been coming in.
Thank you so much, Erin. So I've been trying to go through the Q&A as we go along. And we do have about 13 questions in the Q&A right now. So I'm going to start down at the bottom and try to work our way up. What constitutes a change in private plan? Is this simply wanting to move to a new carrier in the future?
A new carrier would be a change, but also if you are offering different benefits, if you're changing the contribution requirement, really any change in the terms and conditions of the plan is something that you would need to bring back to a vote to your employees, because they have the right to receive the benefits that they voted for. And so if you're changing those benefits, they have a right to vote again.
Okay. And how long does it take to receive provisional approval once the application has been submitted with all the required information?
So we are committing to make sure that they're all done within 10 business days, but I can tell you that thus far, we've been able to do it much more quickly than that. we haven't been inundated with private plans. So we've been able to turn them around very quickly, but we are committing to doing it in less than 10 business days.
Okay. And is the policy number a required field?
No, right now the policy number is not a required field because we know that some insurers are not putting a policy number on the declaration documents. But you do need to have your declaration document, and that is something you will have to upload.
Okay. And are there any plans to remove the survey requirements?
I assume they mean the vote, because we don't have a survey requirement, but the voting requirement is something that is in statute, and we have not seen any legislative proposals to eliminate that.
And if private plans have to be approved by the authority by March 31st, 21, what date does the application have to be submitted to the authority for approval by?
As soon as possible. Well, definitely as soon as possible, because then you'll know what you're doing with. But if you work back to the fact that we're committing to try and get everything done within 10 business days, getting your plan in before mid-March is the prudent thing to do. If you get it in toward the second half of March, we'll make every effort to get the application reviewed as quickly as possible. But please don't wait till the last minute. We do have situations where people submit incomplete information in their application. And if that's the case, then you won't have it approved by March 31st. So you really want to get it in as soon as you can.
Okay, thank you. Can employers still go to a private plan after March 31st? And I believe
Yes. You absolutely can. The reason we're really making this push for March 31st is because we know that many employers are saying we don't want to participate in the program and then come back out. We'd rather sort of maintain. But you are absolutely able to change your mind and start with the public plan option, make your contributions to the paid leave authority, and then sometime later offer a private plan. You just have to understand that the contributions that made to the paid leave authority will not be reimbursed simply because you decided later that you want to offer a private plan.
Okay. And how is a bond amount determined for a private plan?
So the bond amount for the Shorty Bond for a self-insured plan is calculated at the estimated value of a year's worth of contributions from your employees.
And would the employee be eligible to receive benefits from the Connecticut paid leave program and the employer's short-term disability program, which I know we've been asked a lot in the past?
Right. So this is a question that we do get asked a lot. So if you have, as I mentioned, a short-term disability policy will not be sufficient to be a private plan. So, but you could absolutely choose to be a public plan, participate in the public program, and then also offer your employees a short-term disability. It's just a question of how those benefits will be structured. Most short-term disability policies that we have seen say as part of their contract that the employee would need to use employer-provided benefits or state-provided benefits before they can access the short-term disability. And so if you have a policy that says something like that, your employee would come to the authority for income replacement and then would use the short-term disability either to supplement the benefits provided by the authority, or they would access the short-term disability policy benefits only if they need continued income replacement after their benefits from the authority are exhausted.
Okay. And if an employer is taking contributions on behalf of their employees now, and later on they're approved for their private plan, is the employer allowed to give their contributions back to the employees?
Yeah, so if you are, really the prudent and sort of the star employer, the one that we like to hear about, you already started taking your deductions. but you're working toward your private plan and you're going to get your application in sometime very soon. And then you get your approval, you have two options. You can either reimburse your employees for the contributions that you've already withhold, or you can use those employee contributions to help fund your private plan. The statute allows you to take those withholdings and use it for the private plan. You just have to be very careful to keep it segregated and only used for that purpose. You can't pool it with other benefit programs.
Okay. And is an employer required to notify their employees with the plan guide 2 weeks in advance of the vote? Or is the 2 weeks required, or can it be 1 week?
So that's a great question. And that's something that our board of directors really thought a lot about this past summer when they were developing the policies for the private plan. And we came upon the 2 weeks because we felt that that was the reasonable amount of time to make sure that employees had time to really consider their options. So the 2 weeks is a requirement under the Connecticut paid leave policy.
Okay. So plan isn't approved by the employees initial vote for a private plan. When is the employer able to try the approval process again?
You know, I'm smiling because we have heard that question before. We don't have specific rules. We don't have a specific waiting period to vote again, but we do have the requirement that the employer cannot coerce the employees. So if the employer feels that the employees didn't understand the private plan, or the employer says, oh, well, my employees didn't like this private plan, let me offer you a different, maybe a better one, and let's try this again, that's perfectly fine. But the employer cannot hold a series of votes simply to sort of browbeat the employees into ultimately agreeing to the private plan. And that is something that we can audit.
Okay. Let's see. So we just answered that one. If a union represented workplace and the union has to give permission to the employer to conduct a vote, including union members, otherwise direct dealing is a potential violation of the labor law LRA.
Yes, we have heard this question before. This question came up actually several months ago. Our answer is twofold. One, the statute is very clear. There has to be an employee vote. So we have no authority to waive or offer alternatives to a vote by all employees. Two, we certainly cannot waive or alter the NLRA, the National Labor Relations Act. So it is incumbent upon the employer, most likely in consultation with their labor lawyers, to make sure that they comply with both sets of laws if they choose to offer a private plan.
This one says, how long do you have to give for the vote? So once you've given for the 2 weeks review, can we say you have to vote within 48 hours, for example?
Yeah, we're, again, just like we didn't set up specific parameters about how often you can have a vote, as long as it's not coercive. We don't have specific parameters about how long the vote has to remain open, as long as it's reasonable. And reasonable length of time really depends on the size of your organization, the nature of the voting process that you're allowing. So you can set a short amount of time that's perfectly reasonable, or you can set it to be a week, whatever is reasonable and gives your employees a true opportunity to review and make their decision. And again, reminding you that the majority vote has to be of all of your employees. It's not a majority of those who voted.
Okay. How often do the employees vote need to cover new employees? Is this just a snapshot?
It is. So the vote will be of the employees who are employed by you at this time. And so the private plan has to cover all of your employees, including new employees, during the approval period. So you have a vote now, it gets approved. Now you have a private plan for the next 3 years. And new employees who come in the next 3 years will be covered by that private plan. They don't have a new vote every time somebody new comes in. You will only have to vote again once your time is up or if you change your plan.
And this one is, I work for a university and student workers are included in our employee pool. They must have contributions taken from their checks, but very few of them, if any, are going to qualify for benefits based on their pay. So I think the question here is, it's going to be difficult to get these students to vote, if they even vote, for a private plan. So must those who clearly will not be eligible for the benefits be included in the vote?
Yes, they will. They have to be included in the vote because they are employees. And that is a perfectly valid consideration for those employees, because under the Connecticut Paid Leave Program, your eligibility is based on your earnings from all of your employers. Whereas for a private plan, the eligibility is based on your earnings with that particular employer. So if you are an employer which has a lot of part-time employees, those employees may think that they'll have a better opportunity if they're in the state program. It's just something that they have the absolute right to consider, and that may be their best interest. But the vote does have to include everybody who's employed.
All right. Thank you, Erin. And we have another one here. Is there any approved vendor to use for the voting, such as SurveyMonkey, or can employers use their vendor of choice? That's
Yeah,
a
we
good
don't
question.
have an approved vendor for the vote. What we require is that the vote be anonymous. So,
Okay.
sending out something that says, email me back isn't a great option because emails come with names.
All right. And as of right now, we have one question left. Is there any exemption for an employer that only has one remote employee in Connecticut? We provide PTO and we're self-insured for short-term disability for this employee. And we also provide long-term disability coverage.
So there's so much in that question. I'm so glad that we have a few minutes to answer it. So the statute says that if you have one or more employee working in Connecticut, you are a covered employer. So the fact that you only have one in Connecticut does not change your obligation as an employer. So that you are an employer, you have an employee working in Connecticut. The short-term and long-term disability is great, and we really do appreciate employers who do offer good benefits to their employees. However, neither short-term nor long-term disability benefits cover the whole range of leave reasons and benefits that the paid leave program does. So that would not be sufficient in and of itself to qualify as a paid leave program. So what you as an employer need to do is consider whether it just makes sense to have that employee contribute to the paid leave program like other employees, remit the 1/2 of 1% to the paid leave authority so that that employee can access benefits through the public program, or whether it makes sense for you to obtain a policy that applies only to that one employee. We've heard from employers who have made decisions on both sides of that coin. Many employers say, you know what, it's a whole lot easier to just withhold the money and remit it, and that way we know our employees covered. Other employers have said, we offer a paid leave program already. We're already in New York, and we already have a statutory requirement to do so. Or we're in Massachusetts or New Jersey. And so we already have a relationship with an insurance company that is approved, and it's just easier for us to get a Connecticut only plan for that one person because we're already doing it for all of our Massachusetts or New York employees. So that's a decision you'll have to make.
All right, and this next one is very similar, but it's just based on residency because their COVID employees are working remotely. So they want to know if an employee is performing work for Connecticut but resides in another state and they're working remotely, are they eligible?
This is a really good question. We've been getting this a lot because of COVID. And so the answer is for for employees, we don't look at residency. We look at where they're working. If your employee is working at home due to COVID, and it's really a temporary, although extended, because COVID's been extended basis, then we'll still consider them to be an employee working in wherever they worked before. On the other hand, if you've made the decision that, wow, teleworking is our new future and we're all going to stay at home and we're all going to work from home, then they will be working in that new state. Basically, what we do, and this is probably how I should have started, is we follow wherever you treat your employee as working for purposes of unemployment, if you're subject to unemployment. So if you've got an employee who normally works in Connecticut, is teleworking from Massachusetts due to COVID, but you're still paying Connecticut unemployment, we're going to consider you as working in Connecticut. If they are not subject to unemployment, we have a 4-part test to figure out where they're working, which is based on the unemployment rules. We actually have an FAQ about that on our website.
Okay. For variable pay, should we look back into 2020 to calculate an estimate for the private plan surety bond?
Good question. Yeah, I think that is a reasonable approach to determining what the likely contributions will be, assuming that you have a pretty good faith basis for assuming that the 2020 pay will be equivalent to the 2021 pay.
What are the other deadlines during the year to submit a private plan application? This person listed June 1st, August 31st, and November 30th. Is that correct?
Yeah, so there's that one slide that says, in order to be approved, you need to submit the application at least 30 days before the contribution is owed. So you are in the public program, you're contributing to the public program, and then later on in the year, you decide that you want to apply for a private plan on a going forward basis. You can do so. As I said, I think, I don't remember what slide it is, but we set up the policy to say it's 30 days before the contribution for that quarter is owed.
Okay, great. Thank you so much, Erin. So that concludes our questions for the moment. Oh, we got a couple more rolling. I just want to let everybody know I'm going to drop a couple of links in the chat for our Contact Us portal. We're going to try to get to everyone's questions, but if you do find that you have questions later on, please submit those to our Contact Us portal, which I will put in the chat, as well as a couple of other helpful links. For our next couple of questions, Erin, they're asking, is this for groups of one or larger, or is there a maximum size for the group? And I guess we're talking about a group of employees here.
So, yeah, I'm having trouble understanding that question. There's no maximum, right? So an employer is one or more. An employer is someone who has one or more employees working in Connecticut. There's no cap. This may be connected to Families First Coronavirus Relief Act, which said that if you are a employer with 500 or more employees, you're not subject to that law. That 500 or more employees was really restricted just to the Families First Coronavirus Relief Act. That is not a cap that applies to Connecticut Paid Leave Program.
Okay. And if the employees approve the private plan and afterwards an employer decides to change the insurance policy to provide larger benefits or extended coverage, does another vote need to be counted?
Yes, any change requires a new vote.
Okay. All right. And just so everyone knows, you will receive a follow-up email from Zoom, which you registered at, in about 2 days. And that will include a link to the recording of this presentation, as well as a PDF link of the slide deck itself.
Okay,
So yes, we will be sending the slide deck.
Amber, I see one last question before we have to close, which is, what if you registered and didn't indicate that you were interested in a private plan? That's perfectly fine. You don't have to go back and change your registration. You just have to submit the private plan. Application itself. There's no, we asked for it at the registration stage because we wanted to make sure we were communicating with people who knew they had an interest. But if you registered without saying that and now you've changed your mind, just go back in and go to your business on your account and click the application tab, and you're good to go.
Okay, great. All right, do we have any other questions? No, doesn't look like we have any other questions.
Thank you
All right,
again for
thank you
inviting
so
us
much.
today.
All right, yeah, thank you, Erin. We appreciate, all of these tips and answering all of our questions about these private plans. And we've appreciated the Connecticut Paid Leave Authority hosting all of these webinars as well to help answer the questions of our accredited businesses. So thank you again, Erin. If anybody has any other questions, you can always email us at BBB. You can email your BBB contact, and we will connect you to the correct party. So everybody have a great rest of your afternoon, and thank you again.
Thank you.
Great, thanks, Luke. Have a great day, everyone, and thanks for joining us.